Hello, greetings from me and my team to all of you who is watching, and especially our lecturer, Dr. Morgana. Without her, we wouldn't be here right now. So I'm gonna tell you and I'm gonna elaborate about Bolam test, a higher standard of care. So what we're gonna go through here is very simple but yet informative. We're gonna go through the introduction to the Bolam test. What is Bolam test, their background, and what is it for? The Bolam test application in England and Wales, and also the application of the Bolam test in Malaysia. Is it applicable? Are they using another legal principle? And also the conclusion to conclude all of the points that we're gonna go through together, alright? So number one, we're gonna go with the introduction to the Bolam test. So Bolam test is an innovation version of reasonable man test. Okay, so first of all, how can we know if there is a breach of duty? We need to know the standard of care first. What is the standard that people need to follow? So by that, how can we know the standard of it? We can apply the reasonable man test, which is in the case in Blyth and Proprietors of the Birmingham Waterworks 1856, where the judges Alderson B stated that negligence is the omission to do something which a reasonable man, guided upon those considerations which ordinarily regulate the conduct of human affairs, will do, or doing something which a prudent and reasonable man will not do. Simply, what the judges here trying to say is that a reasonable man will not do something negligent. So who is the reasonable man? Reasonable man is someone who have reasonable thought, is an ordinary and average people, and that's that. So if you put a reasonable man in the case shoe, what would the reasonable man do? That is simply what is reasonable man test. But how about the standard of care in medical negligence? You cannot expect an ordinary man, a regular ordinary man to know how to take your blood, to know how to take an X-ray from you, to know how to use the MRI. You cannot expect that from an ordinary people. You cannot use reasonable man test. So here comes the Bolam test. Bolam test originated from the case Bolam and Friend Hospital Management Committee 1957, which I'm gonna elaborate what is the fact inside the case. The plaintiff undergo an ECT, which is electroconvulsive therapy for mental illness. But the doctor, when the patient go into that seat, the doctor didn't restrain him or give him any relaxant drug for him to undergo the ECT. And eventually the plaintiff, the patient, suffered from a fractured bone because the severe contract muscle that he go through. So because of this fracture, the plaintiff wanted to sue the doctor, but eventually it held the doctor is not guilty. How he is not guilty? He doesn't give any relaxant drug, he doesn't even restrain him, and the plaintiff suffered a damage, a physical injury. How can he not be held guilty? So McNair J, the judge in the test, the judges in the case said that, quote unquote, he is not guilty of negligence if he act in accordance with a practice accepted as proper by a responsible body of skilled medical man skilled in the particular art. So what he is trying to say here is the doctor is not negligent. Because why? Because the practice that he did, even though he doesn't follow a mere precaution, the practice he did still accepted by a medical body authority. It's accepted by some medical authority. So because of that, Bolam tests show that if the doctor practice is aligned with the medical body, he will not plead guilty. He will not be guilty. So that is a Bolam test in a nutshell. My colleagues gonna My colleagues going to elaborate more on it. Thank you.
Hi guys, my name is Jiahui. Today we are going to discuss about the Bolam test. The Bolam test is a test for professional negligence. It sets out the standard of care for skilled professionals. It applies in relation to both treatment, diagnosis, and the giving of advice about risks inherent in medical treatment. It is based on the direction to the jury of a High Court judge, Malaysia, in Bolam against Friend Hospital Management Committee 1957. So for this case, Bolam case, the doctor has failed to give relaxant drug and failed to give um, the warning for the risk and also failed to avoid the injury. However, the court held that the doctor was not in breach of duty. The House of Lords formulated the Bolam test. A medical professional is not guilty of negligence if he has acted in accordance with a practice accepted as proper by a responsible body of medical men skilled in that particular art. Putting it the another way around, a man is not negligent if he is acting in accordance with such a practice, merely because there is a body of opinion who would take a contrary view. There are a lot of cases which use the Bolam test. The first case which used the Bolam test is the Bolito against City and Hackney Health Authority, followed by the Mene against West Midlands Regional Health Authority for examination and diagnosis purpose. And then the case White House against Jordan also used Bolam test for the treatment and clinical judgment. And the case Wilshire against Asset also use the Bolam test for treatment and clinical judgment. It is said that a junior doctor owes the same standard of care as a qualified doctor. A doctor is not negligent if he is acting in accordance with such a practice, merely because there is a body of opinion that takes a contrary view. So now we are going to look at the standard of care, which is the level of expertise. In the case of nettership against Western, it concerns about a learner driver. It shows that people who are learning a skill must exercise the same standard of care as those who are already proficient in that skill. In the case of Wilshire against Access Area Health Authority 1988, the court held that junior doctors are required to adhere to the same standard of care as those who are more senior. If judges choose between different bodies of expert opinions, it must be on the basis of very unreasonableness, a test which has proved extremely difficult to satisfy. And additional information for you is that in 2015, the UK Supreme Court in Montgomery against Lanarkshire Health Board held that Bolam should no longer apply in the context of negligent non-disclosure of information about risk and visible treatment alternatives. The House of Lords might have taken the opportunity to make radical changes to the concept of the Bolam test when they recently considered a medical negligence case, which can be found in the case Bolito against City and Hackney Health Authority in a long-awaited decision. The House of Lords considered two issues in the appeal case. The causation where there is an omission as opposed to an action, the application of the Bolam test in medical negligence cases. You must be clearly noted that Bolam tests should not apply in cases that has issues with the informed consent. This can be found in case Sideway against Board of Governors of the Bolam Royal Hospital 1985. Doctor should have duty to tell the patient of the inherent and material risk of the treatment proposed.
Hi, my name is Wei and I'm going to talk about the advantages and disadvantages about the Bolam test. First, for the advantages of the Bolam test is protection of medical professions. Doctors, they had enjoyed the protection in law that Bolam has brought for many years, and it is important to consider some of those cases that has best illustrate the scope of its effect upon clinical negligence litigations. And patients, they may have unreasonable complaints to the medical professions, and through this case, it will certainly would have a great defense for them. And doctors, they are allowed to make mistakes so long as they are mistakes that might be made by a responsible body of doctors with equivalent skills and experience, exercising a reasonable standard of care. And of course, the decision that has been made needs to be supported by medical evidence. And next, we're going to talk about the disadvantages of the Bolam test. First, it is the potential of injustice. And here we have a question, and that is this the correct test for information disclosure to patients or for all matters pertaining to medical interventions in person unable to give valid consent? There are issues involving ethics and the fundamental rights of every individuals. And there are some critics, they had argued that the court should set the standard in such cases rather than a body of medical opinions, no matter how responsible or authoritative. And there is a balance against the rights of a patient to be told about the risk and benefits of the medical interventions. The patients, every patient, of course, have the rights to know about the risk of their medical issue and what opinions or options do they have. But for the Bolam test, it is said that they wouldn't warn patients of risk unless the risk is higher. But the patient should know about it and make their own decision whether the risk is high or low, safe or unsafe. And criticism arose against the Bolam test for the apparent undue deference shown the doctors in medical negligence, with the result that it provided immunity to the medical profession. And doctors were allowed to make mistakes as long as they can satisfy the requirement of the Bolam test. And the next disadvantages is the lack of patient-centric focus and the erosion of trust in patients. Mutual trust is essential to the doctor-patient relationship, since patients who trust their doctors are more likely to be open with their doctors and derive maximum therapeutic benefits. But unfortunately, it is inevitable that with the increase of the medical litigations and the publicity that accompanies it, the patients will increasingly view his or her doctor with suspicions. And the Bolam test would appear to have enlarged the spectrum of medical practice to include the role of moral arbiter, and it could have resulted in a shift of focus from the patient's interest to reliance on medical testimony. This is the end of the advantages and disadvantages of the Bolam test.
Hello, my name is Jun Fong, and I will be talking about the difference in legal framework of Bolam's test in Malaysia. In the Malaysian court approach, Bolam's test was applied to determine the doctor's standard of care in relation to the treatment and information given to the patient prior to 2006. It can be said that there is not much disparity between both England and Malaysia when it comes to incorporating Bolam's test. However, it is still important to note that there is still a difference, such as in the aspect of informed consent. While both England and Malaysia have acknowledged informed consent, the Malaysian courts have placed a stronger emphasis on the patient's rights to be fully informed of the risk of taking a treatment before it is conducted. The case of Roger v. Whittaker, 1992, can be regarded as highly significant in relation to the Bolam's test in Malaysia and the discussion to the standard of care in professional negligence cases. As the Bolam's test mainly focuses on whether a doctor has followed a procedural practice that is accepted by responsible medical professionals while not necessarily considering the information that is provided to the patients in regards to the potential risk. The case of Roger v. Whittaker 1992 introduced a new principle in which there is emphasis placed on the informed consent of the patients as they have a duty to warn, establishing that it is compulsory duty of a doctor to warn the patients regarding any potential material risk involved with the procedure. This shifted focus on the doctor-centric approach of the Bolam's test and applied an extra layer of standard of care by medical practitioners as Roger V. Whittaker case introduced a patient-centered element. Furthermore, the Malaysia disposition of on the Bolam's test is one where they acknowledge its importance in identifying certain aspects of medical negligence caused by medical practitioners. However, it is not necessarily conclusive enough that it has any relation to all of the aspects. In some cases, they may go as far as to disregard the Bolam's test as they find that the case of Rogers v. Whittaker test is one that is more appropriate. So under the case of Fu Fiona v. Dr. Su Fuk Moon 2007 is a landmark decision in Malaysia's medical negligence law. Traditionally, Malaysia followed the Bolam's test, which held that a doctor is not guilty of negligence if he is acting in accordance to the practice accepted by a responsible body of medical men that is skilled in the field of medical. However, through the introduction of Rogers v. Whittaker test, the responsible body of opinion in the medical profession is not conclusive in determining the practice of another doctor. Through this test, the court is not automatically bound by evidence but is allowed to question the practitioner in order to scrutinize and ensure a certain standard set by law is followed. The federal court, in the case of Fu Fiona v. Dr. Su Fuk Moon, overturned the Bolam's test, in this case stating that it has no relevance to the duty and standard of care in providing advice to a patient in regards to the potential material risk associated with the proposed procedure, despite being bound by the law to do so. Therefore, the decision of the case of Fu Fiona v. Dr. Su Fuk Moon departed from the standard usage of Bolam's test and incorporated Rogers v. Whittaker's instead, as it allows the court to decide upon evaluating evidence. This does give them the final say, whereas the former, which is the Bolam's test, will defer to the opinion of a medical profession, which may be quite subjective. In conclusion, the Malaysia stance on medical negligence, although quite similar yet noted a significant departure from the standard procedure of the Bolam's test, which is often being incorporated by England. That will be all from me. Thank you very much.
Hi, my name is Chloe Quay, and I will now be evaluating the mentioned cases that shapes Malaysia's jurisprudence of medical negligence laws. For starters, the first case that was discussed by my groupmate was the case of Rogers and Whittaker, the Australian case that Malaysia's courts follow. As mentioned, this case is the foundational pillar that established the Bolam's test's incompetency when it comes to the standard of care for a doctor to give medical advice or the disclosing of risks of a certain treatment offered to the patient. This actually reflects the English case of Montgomery. So the advantages ensued includes achieving justice from the point of view of a reasonable patient. The reason behind said case is that a risk would be material. When it is warned of it, when a patient is warned of it, the patient might attach some significance to it. Before a patient decides whether to reject or accept any offered treatment, the patient should have full knowledge of all the risks it entails. If not, can you really say there will be full consent even if they agree to it? Not really. So besides that, by following this case's legal principles, the courts will be given more discretion in deciding whether there is or there was a breach of standard of care across professionals that are not just limited to medical professionals. So this can be seen as a shift from medical opinion to judicial opinion, according to Marini Arumugam and Hima Lathanayar in their article titled "The Paradigm Shift in Establishing Standard of Care in Medical Negligence Cases in Malaysia." Furthermore, Rogers and Whittaker was first followed by the Malaysian courts in the case of Fu Fiona and Dr. Su Fuk Moon, which was also mentioned by my groupmate, so I will just focus more on its effects on the Malaysia's legal framework. The evaluation of this case is similar to that of Rogers and Whittaker due to the decision of discarding the Bolam test in regards to medical advice and disclosure of risks to a patient. To add on, the verdict in this case reduces the reliance on expert opinions by the court, which arguably reduces the chances of medical professionals closing ranks to protect themselves by setting their own standard of care. After Rogers' case and Fufiona's case, the courts can now question professionals and scrutinize their practice to ensure that the standard of care set by the law is adhered to. However, there are some drawbacks because this case has its negative influences to the Malaysian courts due to the lack of clarification on whether the Bolam's test is still relevant in terms of the areas of treatment and diagnosis. Fufiona's case only addressed the usage of Rogers' case in the areas of medical advice. So the ambiguity of this caused major confusion in Malaysian laws of medical negligence. But after a few years, thankfully, the federal court case of Zul Hasnimar binti Ahsan Basri and Anor and Dr. Kupu Velumani P and others cleared the fogs by making the distinction between the tests for diagnosis and treatment and medical advice. It was held that for cases disputing over the practitioner's diagnosis or treatment, the Bolam test will still be used to decide whether the standard of care is met with regards to the Bolitho addendum as support, so that you can say that the Bolam test was slightly modified to make sure it is logical. Whereas for Rogers' case, it will only strictly apply to cases where the doctor fails to disclose all relevant risks of any chosen treatment plan, therefore breaching their duty to advise the patient of the risks. The case of Zul Hasnimar provides the legal certainty that has been absent, so it helped solidify the precedent for Malaysian courts to follow. That will be all from me today, so thank you.
Hello, I'm Lianson, and I'll be wrapping up today's discussion. In conclusion, for England and Wales, the Bolam test is a fundamental guiding principle in professional negligence cases. It emphasizes adherence to accepted professional standards. It is also determined by a responsible body of medical opinion. Next, for Malaysia, its legal framework incorporates elements of the Bolam test. It includes the Bolitho addendum for judicial scrutiny. It ensures professional opinions are reasonable and logical, and also it has greater scope for judicial intervention to protect patient rights. Finally, let's do a comparative analysis. Both jurisdictions prioritize professional standards. In Malaysia, its approach balances professional autonomy with accountability. It also reflects differing legal priorities and protections for patient rights. Here, we have the reference list we use on this discussion. Thank you for watching, and goodbye.